time once again for Community Forum, and we're very lucky to have back with us live in the studios this morning Howard Gale. Howard Gale is a lifelong activist. He came of age during the Vietnam War protests and the struggle for farm workers. He was a founding member of the Northwest disarmament group Live Without Trident, the Boston group Central America Solidarity Association, the Northwest anti-war group SNOW, Sound Nonviolent Opponents of War, and he helped set up the Abe Osheroff and Gunnell Clark Fund in Human Rights at the University of Washington. Howard, thank you very much for coming in and spending time with us again.
Thank you. Thank you, Mike, for having me.
So you have a very interesting story to tell. On June 23rd of this year, you were in New York City as part of a lawsuit against that city for false arrests that occurred during the 2004 Republican National Convention, which, if people remember, there were a lot of arrests back then. Can you tell us about your lawsuit and some of the events that led up to the lawsuit?
Sure. So this all starts, it's hard to believe, it's more than 10 years now. But this was August 31st, 2004. It was just a day before George Bush was actually formally nominated at the Republican National Convention in New York City. A day before he was nominated and 2 days before he was supposed to speak at the convention. On that August 31st, there were quite a few marches, demonstrations, and there ended up being 1,187 arrests. My group, it was a War Resisters League march, and there were 226 others who were arrested with me. And it was very clearly, I'm not going to go through all the details, we really don't have time, but it was very clearly entrapment. We were actually told by the New York City police to have a safe march, go on our way, and then within literally about 200 feet, we were simply netted. We were wrapped up in orange netting and arrested. Now, the arrest was unusual in that we were taken to what was fondly called in 2004 Guantanamo on the Hudson. This was an old bus barn that it was filled with toxic substances and soot and oil and brake fluid. It was a huge cavernous facility that was on the water, on the Hudson. And they had set up these probably 10 by 20 razor wire cages. Okay, these were chain link cages that were topped by razor wire. It was really a horrifying experience. I was kept for about 34 hours. Some people were kept anywhere from 24 to 72 hours. And as a result of that, there were numerous suits. In total, during that 2004 Republican National Convention, there were 1,806 people arrested. And again, I want to say the vast majority of these, it turned out, we don't have precise figures, but well over 90%, and I think the figure is really closer to 98% of those arrested ultimately either had their charges dismissed or were otherwise exonerated. So so that was 2004. It took 10 years for our suit to wind its way through the courts. In 2013, my particular group, the 236 people I was arrested with, got what's called summary judgment from a very conservative federal judge. Summary judgment is where a judge basically looks at the facts that are then in evidence and says this does not even have to go to a jury. It's so clear that the police engaged in a false arrest without any probable cause that we find the city guilty of false arrest. That happened in 2013. For the next year, there were negotiations. A settlement was made in August of 2013. In August, I'm sorry, this was, in 2013, a settlement was offered in late 2013. In 2014, there was a settlement that was accepted January 15th of 2004, this year, a settlement of $18 million. It's, as far as anyone can tell, the largest settlement in a First Amendment case like this. I was one of 4 people who refused to take that settlement and wanted to go to trial. And the reason we wanted to go to trial is we understood that in the last 20 or so years of this kind of policing, where First Amendment rights are simply abrogated, it's sort of a preemptive preemptive arrests of people who are demonstrating. We felt this was so egregious that we really did want to go to trial. And part of what would be accomplished at trial, which is not accomplished in a settlement, is actually a legal vindication. Because when there's a settlement, our side says, well, we're vindicated, we got this money from the city, but the city can then say, which they said in January of this year, the city says, well, we didn't do anything wrong, we're just trying to do what's best for the people of New York. We just want to settle and move on from this. Okay, a trial would prevent that. And so what happened is, at the end of June, we had a trial. It went rather quickly, and on July 2nd, a jury in federal court came back with a very clear verdict. And that is, not only did we deserve compensatory damages for our arrest, but they actually found punitive damages. Now, a little bit of explanation is in order on that. When our trial opened, the city lawyers said very clearly to the jury, they said, you must find, there were two people, two high-ups in the police department, two chiefs that were responsible for our arrest. And those two people were on trial. The city made clear to the jury that in order to get punitive damages, we had to prove evil or malice. And they stressed the word evil intent. So it's beyond just, oops, we made a mistake. There had to be an intention to arrest us when they knew it was not the right thing to do. And it had to be malice or evil. And a jury, astoundingly, came back and found exactly that. And I think this vindicates my belief that it was very important to take these things to trial.
So the other cases, the 90%, none of them felt that taking it to trial was the optimum strategy, or did that come from them, or did that come from the lawyers that are running?
No, I think the problem is, and this goes back, this actually starts in some ways back with WTO in '99. In the last 15 years, there's been many dozens of cases all over the country in which protesters are preemptively arrested and sometimes injured, sometimes pretty egregiously injured. And the result of all those is settlement. Every single case goes to settlement. Now, what our lawyers told us repeatedly, the people that were involved in the suit, was that there is nothing at the other end except a settlement, except money. Now, the problem with that becomes a self-fulfilling prophecy. If all you do is settle, you really don't know what the alternative is. We were told that we couldn't go to trial, we shouldn't go to trial. If we did go to trial, we'd get a jury of Fox News viewers who would probably rule against us. Even though our trial was in New York City, the Southern District for New York and the federal court actually draws from a very large pool. In fact, most of the people on our jury were not from New York City proper, but were from suburbs to the north. So we were constantly told by our lawyers, by a federal magistrate, who last October tried to convince us not to go to court, not to pursue this, to settle. We were constantly told there is nothing more than money. And so I think it's perpetuated this myth that there's really no reason to go to trial. Now, let me just say that we didn't get an astoundingly large settlement. I don't think we got what we really should have. The settlement was $40,000 per person. But now compare that to what we were originally offered early on by the city, which was something on the order of $4,000 or $5,000. And then the final settlement, which came about January of this year, would have come to something like $12,000 or $13,000. Me and the group that I was arrested with actually were at the high end of that scale because we had spent so long in jail and because we obtained summary judgment for our arrest. So we would have gotten $13,000, and here we ended up with $40,000 from a jury. Now, that's important because it sends a message. There's literally hundreds of cases that are still percolating through the system, from anti-war demonstrations, from all the Occupy arrests. People now understand that when the city offers a settlement of $10,000, $12,000, it's really It's really a fraction of what a jury would award. So that's one issue. The other issue is, as I said, $25,000 was awarded for punitive damages. And again, that's a jury finding that there was evil or malice in the arrest. And that's a very important message. So I want to just read for a minute. There was an AP story. We got very bad coverage, and part of that is due to our lawyers who decided they really did not want any media coverage for this. But the little bit of coverage we got an AP story on July 3rd. And what's interesting in this is it says, city lawyers said they were disappointed by the punitive damages. Quote, officers were faced with a very difficult policing situation and only made arrests once they realized that such a large and unpermitted march could not proceed safely, the city attorney said. Now, what they didn't say, nowheres in this AP story did they say, we settled in the best interests of justice and in the people of New York. They were found guilty by a jury. And what remains to be seen is whether the city is going to have to make, New York City is going to have to make a decision fairly soon about whether they're going to appeal this verdict. And so I do want to encourage people, before I forget, I set up a MoveOn.org petition last night requesting that Mayor de Blasio, the mayor of New York City, call a halt to any attempts at appealing this decision. It was a just and proper verdict, and for the first time in decades, the New York police were found guilty of abusing people's rights. So the link for the petition I set up is called, it's a tiny URL. So if you go to tinyurl.com/justice2004, that's tinyurl.com/justice2004. And if people could sign that petition, I think it's going to be a way to get a little more media attention, bring it to the attention of Mayor de Blasio. That the way to move on from this and the way to go forward is really to recognize that wrongs were done and continue to be done, and not to try to appeal something that really was a just verdict.
So how does this reflect the, they talk about the police work on this whole concept of broken windows. Have you heard that?
Yeah, good question. So there is this notion, this stems from James Q. Wilson book back in 1982. And in 1994, it became adopted across in New York City and a lot of cities across the U.S. The broken windows theory was this idea that if you stop petty crimes, small crimes, if you stop graffiti, if you stop aggressive panhandling, whatever, fare jumpers, somehow that will prevent disorder and reduce other crime. So you stop small crimes, you prevent big crimes. It's a pretty discredited theory. It's been used for more than 3 decades now. And it also is a theory that gave rise to the stop and frisk. So it's not just a bad theory, it's also a dangerous theory. What I'd like to propose, the police have foisted upon us this notion of broken windows theory. What I think as citizens, we need to make the police accountable for what I want to call a broken rights theory. And the broken rights theory holds that if police can freely violate core constitutional rights for white middle-class citizens, then we have to expect it's going to be a clear consequence that much more egregious human rights violations are going to occur for people of color. And that includes the loss of not just liberty, but of life, as we've seen over the last, well, we've seen this for many decades. So I think there's a liberty that the police feel. Certainly this is clear in New York, it's clear in Seattle, it's clear in Los Angeles, and every city that I've been to, that if police can so freely violate rights of white middle-class people, and the only consequence is that the city pays out some small sum of money, then how much of a free hand are police going to feel in violating people that have much less visibility, that have much less resources to actually challenge them? So what I'm proposing, and that's again part of why I wanted to go to court, is the broken rights theory. Now let's just to put this in context. This $18 million that New York settled for our case, for the 2004 arrests, $18 million sounds like a huge amount of money. But if you actually do the calculation, because New York has a budget of over $53 billion, that's $1 billion a year. If you actually look at that sort of prorated over the course of 10 years that it's taken to settle that case, that comes out to 0.7 of a penny per $1,000 of New York budget. 0.7 of a penny. I mean, that's beyond trivial. It's beyond trivial. So there's really no cost. And then police officers are not held to account. This is money that's paid out of city tax coffers, and police are not held to account. What happened in our trial is that two very high-level police chiefs, it was there were two deputy chiefs, and this is 3 levels below the actual chief of police in New York. 2 deputy chiefs were made to sit in court 8 to 9 hours a day for 6 consecutive days. That doesn't happen when police shoot people. They had to sit in court and they had to explain to a jury why it was that they summarily arrested people and violated our rights. So when they were found guilty and liable for punitive damages, that finding holds them accountable. Okay, this is very different from a settlement in which the city simply pays out money and says no one's to blame. In this case, the jury was very clear. There are individuals that actually are to blame. And in this case, it was Chief Monahan and Chief Galati. And as an aside here, it's worth pointing out that that one of the 2 chiefs that was at trial, Thomas Galati, went on after 2004, after being one of the people involved in deciding to arrest us. He went on to become one of the chiefs in charge of spying on the Muslim community in New York City. So, again, this gets back to what I was saying earlier. I think small abuses inevitably lead to much bigger and more egregious abuses. And that's why, I think as progressives, I think we have to hold police accountable for even the small crimes, because inevitably they are going to lead to much bigger ones.
Well, and as we were talking about earlier before we went live, the only site to carry this story was The Blaze, and apparently when you say as progressives, it sounds like this concept resonates with a lot of people that are not progressives.
Right. So The Blaze is actually the Glenn Beck, the right-wing Glenn Beck news site. The AP did a story. It was picked up sort of randomly by small papers all over the country. It was a small story. That story was generated because I consistently on Twitter and on Facebook was going after some of the AP correspondents, asking them to cover this. We got very bad coverage. I tried, starting in January when I knew we were going to go to trial, January of this year, I did everything possible to try to get a hold of Democracy Now! I never got through. Our lawyers told us that there was going to be a media campaign, that there would be attention brought. Not only was there not a media campaign, I found out after the trial that our lawyers made a decision not to have media coverage because they thought it might somehow disrupt the trial. In fact, the reason they didn't want media coverage is because you can't be telling people for decades the only outcome for false arrest is money. You can't be telling people that for decades and find out, well, actually there is another outcome. And despite all the naysaying and certainly, look, we could have lost the trial. We could have lost the trial. But there's been literally hundreds of trials since WTO. Hundreds of trials all over the country. I'm sorry, not trials. There's been hundreds of cases all over the country. None of these have gone to trial. That's the point. This is the first case that's gone to trial. And it's proven that it is possible, even with a probably relatively conservative jury, to have a very deep, significant finding that, again, individual officers are actually guilty of malice and evil intent. So, again, part of the significance here is, let's think back for a little bit. You mentioned that I was involved with the farm workers. I sort of grew up during a generation where there was the civil rights movement, anti-war protests, and one of the core methods used by all of these nonviolent causes was civil disobedience. This notion of preemptive arrest, this notion of preemptive arrest basically would have made civil disobedience, would have made the civil rights era impossible. People would have been arrested on their way to buses, on their way to sitting down at lunch counters. I was involved in the Trident protests in the 70s, in which we went onto the naval base in Bangor and got arrested and got a huge amount of attention for our cause, which was how dangerous it was to have the Trident submarines as a first strike weapon based here, how destabilizing it was to nuclear policy. That never could have happened. If the police simply could have summarily arrested us on our way to the naval base, there never would have been a story. Farm workers who used civil disobedience to great effect. So this is an incredibly corrosive method of policing, which has actually increased since WTO in the last 15 years. And as a core tool for social change, it's really something that's I think done dramatic harm to progressive movements. So again, it gets back to the reason why we can't simply accept some small sum of money for the police doing these things. We do have to attack the issue and the responsibility.
Because this change has been in lockstep or synchronized along with apparently this strategy of attorneys to recommend people aren't going to get any justice, they should just take the money. I guess that parallels, justice is money and money is free speech.
Well, yeah, no, actually that's a very good point, and I think it's really it's taken a vibrant, dynamic right, which is our First Amendment right. It's taken a vibrant, dynamic right and rendered it as some kind of commodity. And that does cheapen it. It totally cheapens it, both literally, because we're taking settlements. Now, I do want to go back for a minute. The $16 million, the $18 million that was paid out over, it's about 7.6. 7.6 of that $18 million went to the attorneys. $7.6 million. Most of these attorneys were getting $650 an hour. So that becomes a confound because it's really in the interest of the attorneys to settle. These are huge payouts without having to actually go to trial, without having to spend that kind of time. So it cheapens the rights that we have. The other thing is, let's go back to someone like William Kunstler. His idea of taking cases to court was, it's not just about the law. It's also about the exposure, turning it into theater. It's bringing to the public attention a wrong that's been done. And so in Kunstler's view, the win or loss didn't happen in the courtroom in terms of what a jury or a judge decided. The win or loss happened in the public consciousness, in the public sphere. And we've lost that sense. We think that if we get some kind of settlement, that we can just sort of walk away from this. But again, I think very few people in the audience are even going to remember that in January there was this huge $18 million settlement. Again, let's go back a little bit to understand sort of history here. Back in 1971, in May 3rd, 4th, and 5th of 1971, it's kind of hard to believe this, 14,500 people were arrested for demonstrating. It's a very famous case, and a jury awarded $12 million. If you figured out what that's worth today, it's about $46 million. So there was a history in the past of actually taking things to trial and having the public spectacle and getting huge awards that sort of put the brakes on police misconduct. I think we've lost that, and we do need to get that back.
And one of the ways to do so would be to have a legal team, a legal infrastructure that's more supportive of this?
Right. There has to be a legal team which actually takes which at its center are activists. The lawyers cannot be the people that actually dictate what's done. It has to be the activists, and we've turned that around. In our case, not only were my rights taken away by the police in 2004, but in 2014 my rights were taken away by my lawyers. They actually, we can't get into that now, but they actually threw out a lot of the claims that we had. They actually conspired with the city to dismiss a lot of our claims. So we were never consulted about that. So again, I think we have to go back to the Kunstler kind of belief that the client, that the activist has to be at the core of this kind of cause.
And these were pretty big-name lawyers that were representing you, weren't they?
They were. They were. So again, I want to encourage people, go to the Move On petition. It's tinyurl.com/justice2004. tinyurl.com/justice2004. Please sign the petition.
And where do you hope that's going to take things?
Well, I hope it does get Mayor de Blasio's attention. It's a big city, and this is not something that's going to be on his plate. And I'm hoping that a petition is a way to get him to actually make a public statement that we've learned from what happened in 2004. It's not okay to preemptively arrest people for First Amendment activity, and that he'll accept the verdict of the jury and change police behavior going forward.
All right. So, and at this point, then beyond that, anything else happening on that trial?
Well, we're actually right now what's happening is there would be a 30-day clock running for the city to appeal. What's extending that deadline is our lawyers are now trying to get they're asking for over $500,000. I think it's over $1 million in legal fees, and the city is objecting to that. So that's unfortunately drawing this process out. Again, reinforcing the notion that it really is, for our lawyers, it's really more about money than it is about the actual justice.
All right. Well, with that, we are unfortunately out of time. I want to thank you for coming and spending time with us again this morning.
Thank you, Mike. I appreciate it.